What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. What is it? Happy Wednesday. Happy Wednesday. Happy hump day. Hopefully you guys are, getting through the week all right. You guys want to watch some court? I want to watch some court. Let's watch some court. Let's see. What do I have? I've got two clips tonight. They're both fairly long. I think they're both about 30 minutes apiece or somewhere around there. The first one is it's from a new court. Well, it's not a new court. I rarely take things from this court because I'm going to be fair with you guys. The audio is horrendous. It's not horrendous that you can't hear. It's just every mic is hot. You're going to know what's going on. I had the option to turn the volume down. I did not. I'm going to leave that in your guys' hands. So you may want to turn the volume down a little bit. It's just everyone has it sounds like their mouth is right next to the microphone. You'll hear that pretty quickly. But you can hear everything clearly, so you know what's going on. We have a guy who I think he's a sovereign citizen. He doesn't use the script. The reason I think that is he tries to file a bunch of frivolous motions. He has an attorney, though, which, well, he may not have an attorney very, very much longer. But, yeah, just let me know. He at least gives us sound advice, but he's absolutely a moron. He's absolutely a moron for what he's doing, and the judge roasts him. The judge makes fun of him for what he's doing too, so it's good. This is out of Ohio. It's one of the few courts that stream in Ohio. But yeah, so let's just do it. Before I hit that play button, you know what to do. Hit the like hit the like and subscribe. Do your jump kick backflips. Let's go.
All right, this is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right.
Count?
Just a minute. We have to be quiet. This is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so actually I see over here there's a red jacket. I see them. Yeah, okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't...
All right, now that you heard a little of the audio, what do you think? Judge DiSanto's, her jail Zoom... sounds like they're all talking from a tin can, so it's a little different of an audio problem. But you guys think this is too bad? I'm gonna play this entire video, but if it's too bad, I'm just not going to use this cord anymore because there's not a lot I can do. I can turn the volume down, but there's not a lot I can do to clean it up.
I don't see any pretrial motions filed, or did you file any?
I did not. I did not see any warrant for any, so I did not file any.
All right. Now. What's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, Counsel?
It's protected. I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically the...
All right, I can turn it down a little bit. I'll turn it down a little bit. I like giving you guys the option to turn it down because not everyone's going to think it's loud, but I turned it down a little.
Yeah. I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time, I'm not sure what he wants to do. He's never given me a clear answer.
So, Mr. Taylor, are you rejecting the plea offer the state made and electing to go to trial? Is that your decision?
The process, this process here, this pre-trial hearing, I mean, I got motions I'd like to file.
Well, you're not representing yourself. You have an attorney. And so,
I know that.
Well, wait a minute. Just wait a minute. I'm going to address this. And under the rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake, and you haven't asked for that, and there's be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient, listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point is that there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he has reviewed these with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of a number of motions based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, are you rejecting the plea offer?
Yes.
Yes? Okay, then we'll...
All right. Yeah, I turned it. My volume's at about 50%. It does seem a little bit better now that I turned it down. It's not as hot. We might have a tough time hearing the defendant, though. I'll try to translate. He did say yes there. He's rejecting the plea deal. Solves crimes and good times. Thank you so much for the gifted membership. Welcome to the new member. Thank you, bud. I appreciate it. Oh yeah, no, it's absolutely a moron. I've worded that poorly. It should be, this guy's definitely a moron, potentially a subset. But we're getting to that.
We'll have a trial on April the 7th. All right.
Oh, and Judge is in the top middle. I saw someone ask. His robe is just not black. It's gray with is red around the collar, which you can see the red, but the rest is gray. It's just a different colored robe. You can't really see it too well in this video, but in his other dockets, you can see him kind of walking around with it. So, yeah, it does look like a choir robe more than a judge robe.
So, does the state expect this to take more than 1 day?
No, the state expects this to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those were due by today, so if you've got them, get them to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I'm going to ask to have my attorney removed. I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV. This is from going through the law book and studying day in and day out. Everything I got the case numbers, case laws. I got.
Motion, what kind of motions are you talking about, Mr. Taylor?
But one is a motion to suppress. I got one here. It's
motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
It'd be
Well, if you know so much about the law, you should be able to answer that question.
I mean,
I've got an attorney here who knows the law and tells me there's no basis, and now I've got you telling me there is, and I ask you what it is, and you can't tell me.
I asked you to file this motion, and
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
got from my paperwork here. None of you organized here at the same time.
So you have an answer. What is it you would seek to suppress? Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney move from the case and have another one, please.
Wait a minute. I'm having trouble understanding you. I can hear you.
I'd like to remove my attorney and get another one.
Okay. Well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he is not, he shouldn't be your attorney, and you've given me no reason other than the fact that you don't like what he's saying, and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything, because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
Yes, I have grounds.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm trying to be respectful. Wait till you're done talking.
I'm sorry, what?
I'm trying to be respectful, man. Wait till you're done talking. You got only once for interrupting.
Okay. I asked you to answer my question, and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law. I could read a book on brain surgery, but that wouldn't make me a brain surgeon. You can read a book on the law, and it doesn't make you a lawyer. Now, any other things you want to bring up, Mr. Taylor?
Represent myself?
Well, that would be the biggest mistake you've ever made in your entire life. Based upon what you've been telling me, I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand you're mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You're on trial. You don't get to participate in your defense because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Oh, absolutely, and that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery yet. I'm missing 12 things that I'm not discovered. I'm begging for.
Well, he's got the discovery. Let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, my understanding, he's given you more than what most defendants get in these kind of cases, because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of what they say are the buys, right? And then you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct, yes.
All right, so I don't know what you're talking about when you say you don't have discovery, because you've got everything that he's got. And that's it. Discovery is what he's giving you what he has.
My discoveries don't even have counsel eyes only stamped on them.
It doesn't have to have a stamp on it. It's done by email.
And same time, I get a piece 1 week, I get a piece 2 weeks later, and I get a piece Monday.
All right. Well, good. It gives you something to do. So what? We still got 10 or 12 days to try. But again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
Well, I'm afraid of.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. The court, we're going to send out our jury notices today. The state's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get maybe you can find somebody to be willing to take the case and go to trial on the 7th. But that's going to be on you. If you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would say.
I represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the law?
I think my percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
Yeah.
He said his percentage would be higher. His percentage of winning would be higher if he...
Oh, yeah? What do you think that would be?
I don't know.
Well, give me the odds. I'll take that bet. Because you're absolutely 100% wrong.
I am loving this judge so much, and what he just said just cracked the prosecutor up. What are the odds? Come on, give me. You're gonna have a higher percentage of winning this case if you're representing yourself. That might be the dumbest thing he said so far today. And Peg, you're killed in the chat today. I think I've laughed at everything you've said. This one's fun. I told you guys, it's good. I think the audio is better. It's at 50%. I just gotta remember to turn it up for the next clip. But I think the defense attorney is still he's still really loud. I wish yeah. Let's just go on. I'm gonna stop complaining about it.
Everything you're saying here is exposing the stupidity of your position, and for me to allow you to represent yourself will be guaranteeing you a conviction. You'd be convicted of everything. You don't know what you're talking about. Have you ever picked? Do you know what the word voir dire means? Okay. Do you know what the separation of witnesses is?
That's one of my motions. Motion to seven.
Well, we don't get separation of witnesses. I ask you.
Yes. Yes.
What is okay? So what is it?
That's one of my motions. No, your motion is to suppress evidence, not to separate witnesses. This guy's awesome. I say he needs to represent himself. I disagree with the judge. He's a genius.
Huh?
Motion asked him to file.
Okay, well, that is filed at the time of the trial. When we start the trial, that's an oral motion. What kind of a motion did you want him to file?
You have to give me time to get it.
No, you're the one that claims to know more than he does. You should have been prepared to tell me. If you've got all these arguments, don't tell me you got to sit there and try to figure this out, because we're not going to sit here all afternoon. You tell me what it is you wanted him to file. You just told me you wanted him to file something. Tell me what it is you wanted him to file. Don't tell me you got to go look for it.
I'm pretty organized here.
Well, why can't you answer the question then?
Because I can't tell you without.
Okay, well, look at it. You should be able to find it. I'll give you 15 seconds. Find it.
Ready? Go. Look at him. He's like, I know the answer. I got it. I know I wrote this down on one of these 100 sheets of paper right here with me.
File motion for the rest of my discovery.
There is no other discovery to file, to get. You cannot, pardon me?
I got a list here.
What?
I think he's basing his list off of other people in the jail because he thinks there's a set number. Sir, he thinks
Listen, be quiet. Let me hear what Mr. Kirk's saying. Go ahead.
He thinks there's a set number of discovery items. I've told him that is a myth. Some people may have 14. Some people may have 2. And I've explained that to him. However, he does not trust my advice on that. I do not believe he's missing anything other than there is a lab report that was just filed that I will be taking out to him. But he thinks there's some sort of mythical set number of items.
Okay.
Judge, I can probably shed some light on this as well.
Go ahead. I would like to.
Some defendants believe that they should have copies of the buy money, for example. In this particular defendant's case, those are actually pictures that were on the digital evidence that he would not have access to out there because he's in jail.
Right, I understand.
There are several things that are digital evidence that he physically cannot have access to because he's in jail.
Okay. Well, your attorney has those, and he's shown them to you, as I understand it, right?
Yes, he showed me the digital stuff, but he has showed me, yes, right. But also, if they're going to have PCI experts on the stand, and we get a chance to cross-examine them, shouldn't I have their qualifications and all that for cross-examination? Also,
Cross-examination would be based upon their report.
Also, the submission report to the PCI lab, I don't have, and I don't have the physical evidence or the witness. I got the witness list. I don't have the CI's felony report. I don't have the forfeitures. I don't have disclosure of all evidence and everything from them.
Well, your attorney has it, and he has it, and he's discussed it with you. You don't have to have all that with you in jail. I don't know that you'd have room for it. So,
Ms. That doesn't exist.
Pardon me?
A lot of this that he's talking, so he just said he doesn't have a list of the forfeitures. There are no forfeitures in this case.
Oh,
he
well,
has
there would
the
be, yeah.
CI's. He has the CI's criminal history. He just doesn't know how to read the discovery. We provide the CI's.
Okay. So,
he doesn't understand the read.
Right? Correct? This right here is a signed paper that's the end of my particulars. That right there, if my daughter needed a permission slip to go to school, I can put this on it. Nothing there says that goes to a bill of particulars. There's no date, no stamp, no nothing on my bill of particulars.
all right, well, I don't really, it really doesn't matter. It's immaterial. You have copies of what is filed, and that's what's important.
I can answer this too.
No, Albie, this is just this courtroom is just terrible. I can't explain it. It sounds like this is the best camera quality they have. So on YouTube where you can change the your quality of video, 420 is the highest this courtroom goes, and I had to refresh it 3 or 4 times because I thought it was on my end. Why can't it go higher? No, that's it. And the audio is terrible, so who knows what's going on? But everyone that's on there seems to be okay with it. But yeah, it's rough.
Process.
All right, wait a minute.
I can answer this too. We don't file a bill of particulars in court because it names so much protected information.
Right.
We file a notice of filing. The
Right.
bill of particulars doesn't get stamped or anything like that. It's secret.
I understand, but it still has to have some more, because it can be reproduced. Everything I got can be.
Okay, well, again, you're operating from a complete ignorance of what's going on here. As she indicated, the bill of particulars does not have to be filed with a file stamp in the public file. And in fact, oftentimes it's not, because it names people that are to remain confidential. And in some cases, we've had a situation where the paper picks it up and prints it all before the trial, and then that person had all that information is out there that could potentially prejudice the defendant. And so your complaint about it not being file stamped, it means nothing. That is a big fat zero that means nothing. You have a copy of it, and that's all you need.
Criminal Rule 16C says that it has to be prominently stamped, counsel.
See right there. He keeps making sob-sit arguments. He doesn't use the script though. Now he's saying Federal Rule 16C it says it needs to be stamped. Again, he mentioned the Bill of Particulars earlier. Like the things that he says comes from they're the same arguments sovereign citizens make. That's why I say, is he potentially one? But I agree. I don't think he is one. But he's absolutely a moron.
Eyes only. And everything they gave me.
Well, it's not stamped cancel eyes only. You've got everything in this case. Now, I'm not going to argue with you anymore. All right. The bottom line is, what you're saying is all without any legal merit whatsoever, because you've read a book and you think these things say this and that, and they don't. And you're not entitled to stuff that doesn't exist. You don't have to have stuff that doesn't have to be filed stamped, and nothing that you've told me means has any legal significance at all. It seems to me that what you ought to be doing is focus on the allegations in this case and the evidence that you do have in this case, which is apparently some videos or audios and witness statements and people who are going to testify. That's the stuff you need to be focusing on, not on a whole bunch of stuff that you think you should get that either one doesn't exist or two is you have it and you don't understand it, and that's your fault. And that's just, again, the fact that you don't know what you're talking about. That means
everything.
Pardon me?
I brought so much to my lawyer, and he has dismissed and excused everything. I got this form smoking crack in the video, but he dismisses it and justifies it. It says I'm smoking a pipe, and nowhere in the video I'm smoking a pipe, but he dismisses it and justifies it.
Well, it'll be in the trial. I mean, if whatever the videos show, they show. I don't know what's on there. This isn't about that. We're not going to argue about that. Whatever the evidence shows will be what is going to be introduced at trial if we're going to have a trial. And it sounds like that's what you want. So if you want to have a trial, that is completely fine. We're going to go ahead and send out a jury notice here this afternoon, and we'll summons in the jurors, and we will see you on April the 7th. Again, if you want to represent yourself, again, I would tell you that would be a big mistake. But if you want to file that motion, I will have a hearing on it and give you the opportunity. But I can tell you that you will absolutely have no chance in the world at a trial based upon your performance here today. Because just because you represent yourself doesn't mean you get to bring up everything that your attorney says you can't. Because if he says you can't do it, and he's right, which I'm guessing that he is, because he's been around the block a few times and tried cases in this court, then you're not going to be able to bring it up. And so when you're being upset with him not bringing up stuff you want him to, when he tells you can't, it's not admissible, that's going to be the ruling of the court. And most likely what will happen is you're going to come in here thinking you can do this and that, and you can't, and I won't let you. You'll end up hardly having anything to say on your own behalf. You're not the first person I've dealt with that's represented themselves, or wants to represent themselves. And if you want to do that, you can file a motion. There's a hearing I'll have to go through and ask you a whole bunch of questions that will point out, what a big mistake that is. You'll still have to have a legal advisor to stand by to answer questions for you at the trial. They won't be able to participate, and we won't start the trial you representing yourself and then coming to your senses and finally realizing you've made a big mistake and then say, okay, Mr. Kirk, I'm in over my head, take over. That's not the way it works. Once you start it, you're going to finish it. And so, again, under the law, unfortunately, the court is not permitted to protect the biggest right that a defendant ought to have, which is the right not to be stupid. And unfortunately, you do have the right to be stupid, and you can exercise that at any time. And if you exercise that by representing yourself, that will be the biggest mistake you've ever made. I'm just telling you that. I can tell right now that you're not going to be able to effectively represent yourself. But if you want to, once we go, just be quiet, I'm explaining. If you want to file that motion, that's one motion I'll permit you to file on your own. We'll have a hearing on that, and we'll go through all those requirements I'm going to have to do. I'm done with you now because I've got other cases I need to move on to. This is a pre-trial, not a trial, and I'll make that ruling. And so if you want to do that, I'll have a hearing on that, maybe Monday, and that'll give, and we'll see what's going to happen. Again, I'm telling you, do not try to represent yourself. And because, when you said your odds will be better, they'll be infinitesimally worse. They'll be so much, so bad that you can't even imagine it. And again, these cases, in cases like this where, you need to focus on what the evidence is as opposed to what you think the attorney.
What word did the judge just say? I know infinitesimally. What? I don't know. I don't know what that word was. Did he just make up a word, or do I have the right to be stupid right now?
Attorney is or isn't doing. That's the issue. Look at the evidence that you do have. What is the evidence against you that the state says they're going to present, and then make your decision based upon that. And as far as asking for stuff that's not out there, or stuff that you can't have in jail because it's digital, and your attorney has shown you those things, you have everything that the state has. There's nothing more.
Happy birthday! Kalina, happy birthday. Thank you for spending a little bit of your birthday with us. I appreciate it. Hopefully you had a great day today. We're birthday buddies. I know I've said that already. Mine's tomorrow. So happy birthday, Kalina. I do appreciate you hanging out. Hopefully, I'm just repeating myself. Let's just go.
They can give you. And so, you could file 135,000 motions asking for more discovery. If there's nothing more to give you, they're not going to be granted, So, what you're asking for is stuff that you apparently think you know about that you don't. And again, I don't know where you come up with these 14 items of discovery, but to the extent that you're getting advice from people that are in jail, think about, how smart they are if they're where you are.
You say I'm getting my ideas from everywhere else. Every idea I'm getting is coming from the Criminal Handbook 2018, and everything comes out of it that I've got.
You've got everything you're supposed to get. That means the criminal law book doesn't criminal law book doesn't create things. It just tells you what you're entitled to. The state has provided all that. Your attorney has got it. He has shown you everything other than this last lab report, which just came in, and he's going to give that to you. He just got it today. So, you have it. There's nothing that you are entitled to have or can have that you don't have. So, I don't know. I don't know what else to say. So, all right. Now, we're done. Anything else from counsel?
No, Your Honor.
All right.
No, you're not.
All right. Thank you.
Come see me soon.
I will be out to see you, yes.
All right. I threw my icon at the bottom to kind of make it look a little, so you guys can see it a little bit better. How pathetic did the defendant sound right at the end? His last line, "Come out and see me soon." Oh, it sounded so bad. It's like I don't want him. I don't want him at all. Will you come out and see me soon, please, please? I told you that one was fun. I told you. I have April 7th written on my calendar. I will watch to see if they play that court. I will tell you, that court is one that starts their stream at like 8 a.m. and lets it run till 5 every single day. So they don't stop and start. They just start it in the morning and let it run all day. So that being the case, if the trial does go on the 7th, we might be able to watch it. So hopefully that's the case. But that one was fun. And yeah, after watching it a second time, he's not a sovereign citizen. He's not. He's just an idiot. Listening to too many jailhouse lawyers. Okay. Next one. Let's move on. Next one, we're moving to Judge DiSanto's court. I got to remember to turn my volume up. All right. Turn my volume back up. This is, I'm not going to lie to you guys. I didn't watch this entire hearing. I was doing something at the time, so I kind of skimmed through it. And I don't know, probably the 10 minutes out of the 30 minutes I watched was hilarious. So we're going to watch this. This is Judge DiSanto. What happened today. And yeah, let's go.
So we are on the record in the matter of the City of Wyandotte versus Nelson Puck, 241298.
Morning, Your Honor. Oh, good afternoon, Your Honor. Your Honor, for the record, John Goldberg, P 30758, on behalf of Mr. Hall. So, great. Yeah. Yes.
Yes.
Yes. Please put your name on the record.
Oh, no, Nelson Howell.
Oh, okay. Okay, and so thank you for dressing appropriately for court. Today is date scheduled for the final pretrial. And counsel?
Your Honor, I've had numerous discussions with my client as well as with the prosecuting attorney. We've received all the paper discovery. We were able to track down the...
Did Mike play this already? I didn't see that he played it. I try not to do that. I really do. I didn't see that he played it. Is it just me or is the volume really loud now? I feel like I got so used to being low. I'm going to turn it down a little bit. All right, let's go.
Brief video from McDonald's. They've also received the in-cam video. Reviewed all of that, or some of it. And at this time, after discussing this matter with Mr. Hook, he wishes to avail himself of the opportunity to have a jury trial in this particular matter. We're asking this matter be set for a jury trial.
Okay.
Is that correct,
So,
sir? Yeah. Yes, sir.
okay, let's, good day. Mr. Cayley, can you please place your appearance on the record?
Roger Keeley, on behalf of People City of Wyandotte, Judge.
All right, thank you. So, how does Friday, June 6th work for you both?
What day, Judge?
Friday, June 6th.
Your Honor, I'm not available that weekend. I know for a fact that I'm going out of town, and I'm not scheduled. I'm scheduled this court, I believe, June 5th.
But counsel, what we do is we are doing our jury trials on Fridays.
Right.
So, and then jury selection will be the afternoon.
Of the 6th, and I'm going to be out of town.
No.
Oh,
That's a Friday, right, so I'm saying that would be the jury trial date, but, what about the 20th, June 20th, Friday, June 20th?
I'm sure. I'm fine on that.
Works for me, Judge.
Okay, so let's do Friday, June 20th for, the jury trial date. That'll be at 8:30 a.m. Jury selection will be June 18th at 1:30 p.m. Witness list, exhibit list, proposed jury instructions by May 9th. And then we'll do our final conference May 21st. Yes.
At what time, Judge?
That would be at 1 p.m.
I'm sorry, final conference 1 p.m.?
Yes. Okay.
We said all this and that's fine, but I'm going to start seeking to hire counsel when it came to that time, so just to inform you so you're aware that I'm going to be looking.
And that's your right, sir. And just so you are informing, just so you're informing your attorney that these are the jury trial dates. So not to file an appearance, the day before the jury trial date.
Right.
Or, the day before the final conference and then is going to ask for an adjournment. So you have the right to retain your own counsel, sir. However, make sure that that whatever attorney it is that you're hiring is aware of these dates and that he's filing what he needs timely so that he can communicate with Mr. Goldpaw, he or she can communicate with Mr. Goldpaw and then receive the discovery that Mr. Goldpaw has. And not come to the court asking for an adjournment because that date doesn't work for them, or now weren't able to prepare, or something of that nature.
Yes, ma'am. My only thing is with dealing with attorneys.
I'm sorry, I'm having a hard time.
I want to give a giant shout out to 13. She just sent me the definition of infinitesimal, and I appreciate that. I learned a new word today. And it's a math word. Was one of my strongest subjects. So I should absolutely know that word. So 13, thank you.
I'm sorry, my only problem is with dealing with an attorney, you never know what dates they're gonna have available, so, you know, they said.
When you get for the final pretrial, if you do, like,
Wonder at that time to
yeah, be a dick.
say, because I'm not sure how long it may take me to get the funds together, because I gotta get the funds together.
I understand that. I'm putting this far enough out, sir, that you should be able to retain an attorney and and they should be able to get up to speed timely.
Alright.
So what I'm saying, sir, is that, I have this set out for just under 3 months.
Alright. I'm sorry, man. I'm just trying to make sure that I'm not gonna be rushed into my attorney trying to rush into figuring it out. You know, like, I just wanna make sure I'm gonna get adequate time for my attorney to prepare for a trial. Is all I'm saying, because we've had hard times even receiving information over here in their shoes. So I can only imagine what it would be like getting a new attorney on it.
Well, your attorney would just contact this current attorney who's already received the information, and Mr. Gopal would then send the information to your new attorney.
Yes, ma'am. I'm just kind of worried because I feel like there's more evidence to gain, is what I'm saying. Like, the piece of video they sent us wasn't it. So that's what I'm saying. I know my new attorney's gonna see the full video.
Okay, so sir, this occurred back in September of 24. So what steps have you taken to hire an attorney?
I just sold my home and everything, so we're in that process still. So like, I'm not made of money, Your Honor, where I got just money to throw out at an attorney that's gonna cost a lot. I have to take time to figure out those fundings. So yes, this incident happened last September, but with dealing that, I thought I was gonna get adequate attorneys in this courtroom.
Yeah, I kind of agree with you. He does a fine job, but every time I see him or hear his name, I can't get him chugging a beer on Zoom in court. I can never get that out of my head. He's forever linked to the attorney that, you know, sits in his office and chugs beer while on Zoom. Like that's him now.
And I have not.
Sir, the attorneys that are here in this courtroom are more than adequate.
Yes, ma'am. Yes, ma'am. I'm not gonna argue with you, yes or no, they are. In my opinion, they have not fulfilled their duties.
Well, Your Honor,
So
I want to put that on the record. That is not true. I have done everything that I could possibly do in representing Mr. Hunt. I have filed discovery orders. I've obtained all of the body cam. We learned that there was video that was not provided. We tracked all of that down. I have provided Mr. Hunt with hard copies of the discovery. I informed him that once we got set, and the video that we got, I forwarded to him. I have spoken to him on a number of occasions. I have done everything possible under the circumstances. So I have adequately.
Yeah, so, you know, that's when he was right before. It was either right before or right after his surgery. Like he was in a lot of pain. So I don't really. I give that one a pass. But drinking a beer while your client's taking a plea deal for a DUI, I don't know. Just yeah.
And I believe more than adequately representing Mr. Hunt.
Okay, Your Honor, I was literally told by this man in your lobby, if I wanted somebody to go pull that video that exonerated me, I could hire an attorney. It's his job. It's in his duties as code of ethics. If there's video, if there's any evidence that can exonerate your client, it is your duty as my representation to track that down and to do your due diligence in gaining that information. And he told me out his mouth, I can call your lobby officer in here.
I told him that, Your Honor.
So you can't tell me you've adequately represented me when you told me if I want you to gain the evidence to exonerate me, I can hire an attorney to track it down because you weren't willing to.
That's not true, Your Honor.
Okay.
I didn't say hire somebody if I'm not willing to do it.
Your Honor, I can call in the lobby.
Your Honor, I don't want to argue with him.
Okay.
He can do what he wants. If he wants to hire somebody,
Yes, ma'am.
he's more than happy to. I have these dates down, ready to go, Your Honor.
Okay. Mr. Howard, so are you saying that there's additional video other than the McDonald's video that Mr. Goldpaw tracked down?
Yes, ma'am. Listen, ma'am. It's
Are
clear.
you telling me to listen?
I'm sorry. I wasn't saying it like that. Like, I'm saying like as far as like trying to articulate what I'm finna say. So as far as that video that he just gave me, it's only 14 seconds and only 5 of it even show the incident. And it's a part of the video that they made sure to only clip where it's gonna just, the incident like travel into the frame. It's not even the whole video of what happened there. It's a portion of the video, and by them giving him that, it shows me they have the whole video and access to the whole video, because it was months later, almost a half a year later, that we asked for that, and they gave it to us without a fight. So it shows that the video evidence is there if a lawyer was to actually go and try to subpoena and obtain that evidence. Yes, ma'am.
Well, sir, it appears as though the attorney did subpoena that evidence, requested it somehow, and that is the video that they gave.
Yes, ma'am.
So it's your position that there's more video?
Yes, ma'am.
I don't know where it would be, Your Honor.
I want to know what the relevance of this is. So McDonald's was nice enough. They don't have to. It's a private company. They don't have to give you anything unless the court subpoenas it for him. But they sent him, what did he say, a 13-second clip, showed the crime. That's all you need. That's all you need. What is it? I'm not sure what the relevance of him walking into the scene and leaving the scene would be. They showed the crime.
If that's the video they provided based upon what the request was, and just so you know, sir, that's a private company.
Yes, ma'am.
And it's not a police agency, so it's a little bit of a different process.
Yes, ma'am. But things can be subpoenaed and FOIA. You know, where you have.
I don't believe, no. From a private business, it can't be FOIA.
It could be subpoenaed, Your Honor.
Okay.
That I know.
And the appearance from Mr. Goldpaw did.
That is going to be the new joke. The title charts. Oh, I love it. I love it. I think that's the 6th or 7th time title charts were referenced. Jojo, someone said something earlier about dealing, like he was dealing drugs, I'm guessing. I don't know. I've been paying more attention to the chat tonight than I have the video. I'm not going to lie to you guys. I've been having fun with you guys.
Subpoena that.
And there's more of that video that can be subpoenaed. I'm telling you now, Your Honor, I know this for a fact. They would not just.
How do you know for a fact? Do you work there? Do you work the cameras, sir?
Do you guys work there to tell me it's not?
Sir?
I'm sorry, I'm just asking the same question you asked me back.
No, you don't know. I asked you a question. You're telling me that you know for a fact. So I'm wondering how you know for a fact.
Because they gave us a piece of the video, a piece of it, that clearly shows there is more going on. That there have cameras. There's cameras at so many different areas in that McDonald's. So for you to only send me the piece over the fryer where the incident traveled on shows me that there's more videos, because you willingly brought that piece that would demonize me in that situation.
Okay, so let me just clarify for the record. You keep referring to you, but you're not referring to the court. You're referring to McDonald's.
Yes. I'm not saying you guys, Your Honor. Don't think I'm sitting here pointing a finger at the courts. No, ma'am. I'm saying the people who are trying to press these charges, yes, ma'am, are trying to play with the evidence to only demonize me in the situation.
Okay, Mr. Goldpaw, when you requested the video.
All right, it sounds like it might be a assault type charge. I don't know if it's drug related. I just took that from the comments earlier. So I'm guessing he doesn't work at McDonald's, and there was an incident that was probably an altercation, and that's what he's trying to say, that he wants the entire video so you can see his side of how the event escalated. That's what I'm guessing.
Did you request any and all video? What did you request?
Your Honor, when we filed the discovery order, I requested any and all video.
From McDonald's? Or did this come from the police department?
From the police department, on the original order. When we received that, because the discovery and the police report indicated that I saw something on the video.
Yeah, absolutely. Those things are dangerous. For anyone that's ever worked around one, they are dangerous. I've been hit with the fry basket right out of the fryer and had this really cool looking like spider web burn mark on my arm for a couple weeks. It's move away from that. The cutting board is probably safer.
And then it goes on, which we hear in a second. Based on that, they went out and they got their warrant. When we reviewed the video, there was nothing from, nothing on no McDonald's video. I brought that up to you last time we were here. I brought that up to Mr. Cayley. And I indicated, hey, where is this secret? And he indicated that we adjourned this to get that video, that he would subpoena, and I said, I would too. I came down to prepare the subpoena, to get the subpoena to serve on them. I spoke with Mr. Cayley. At that point in time, he said, let's go see what the police reports have. So we spent quite a bit of time going into the computer system through the police report, and they found that there was an email, by email, that the video was sent to the officer as part of the report.
Okay.
Mr. Cayley got that immediately. This is just before I was going out of town, and he provided me with a copy of the video. I then, the other day, emailed that to him.
Mr. Houck?
Mr. Houck.
Yes.
And he received, though he indicated to me he didn't see that video this morning. And I had it on my computer to show in case he never got it.
Okay. So
yes, I
whether or not the video still remains at McDonald's is unknown at this point, because upon further investigation, the officer did have, or somebody received the video from that date. So, Mr. Gopal, here's what I'm going to ask you to do. Mr. Houck is indicating that he's certain that there is additional video. Whether there is or there isn't, none of us know, because we don't work there, we don't monitor the cameras or anything of that nature. So, I'm going to ask if, please send a subpoena, asking if there's any video from that day regarding the incident. That way, there can be communication to Mr. Houck and Mr. Cayley, and we can go from there. Okay?
He must have something to say, right?
I understand that, but is that fine, Counsel? Okay. You can send that subpoena?
I'll take care of it.
Okay. Yes, sir.
I would like to also state on the record that I'm requesting a copy of my discovery, of all my discovery, videos, including everything. Because I once asked him already and he won't give them to me.
That's not true, Your Honor.
I don't have the copies already after asking him, so I don't.
Your Honor, it's not true that I wouldn't give it to him. I hand delivered him hard copies of the paper in this court.
Okay,
When he said
did
he
you get
did.
those copies?
Ma'am, I got
Yes or no?
copies of
Did
the
you get the
papers,
copies?
not the video.
Sir,
He doesn't have the videos, no.
Sir, did you get the copies of the paper?
Yes.
Okay.
And, Your Honor, when he said, I'll need copies of the videos, they're on a thumb drive, I said, don't worry about it, I'll get them to you.
Okay.
Ma'am, that's not what he said.
Did Mayor win? I need to know if Mayor won. I'm guessing he did if it was funny. Because if he would have lost, it wouldn't have been funny. I miss Mayor. Where's Mayor at?
Yes, it is,
I
Your
haven't
Honor.
received them, and when I asked him, he said, no, I'm not dealing with
I
that
thought
right
he
now.
sent you an email of the video
He
that you
did
saw.
not include any of those videos. He sent me an email of the papers, and then of the video he found today, it's a video of a video. It's not the video. It's a video recorded of the video.
Okay.
So is,
Your Honor, no, it's not.
Either way,
want me to prove it to you right now?
I don't want to argue with you here in court.
No, I'll prove it to you right now.
either way, Mr. Gopal is going to send a subpoena to McDonald's.
Yes, ma'am.
Because the video that was requested was determined to have already been turned over to the police department.
Yes, ma'am.
He's going to send a subpoena to McDonald's.
Yes, ma'am.
They may or may not have the rest of the video.
At this point, probably not. He waited so long to do it.
Sir,
Your Honor, I'm tired. He waited so long. I got this case 2 months ago and all he does is argue with any attorney who represents you.
just one moment.
Because I'm not a doormat.
Sir, nobody
Yeah, I'm waiting
is
too long.
nobody is suggesting you're
Have you
doing
put in a
that.
subpoena yet?
Excuse me.
You just admitted you have me put it in?
Excuse me, sir, because the video that was being discussed and requested was determined to have already existed within the police department. Stop shaking your head at me, sir.
Yes, ma'am.
That is exactly what Mr. Gopal indicated. Now, as far as he's taking too long, Mr. Gopal was assigned this case, let's say you were here, and I don't even think he was the one that represented you at the arraignment. I think that was Miss Medina.
Yes, ma'am.
And then Mr.
Oh, I agree. Gopal needs to take a breath. I would just ask, to be removed from the case and have a different attorney assigned. I mean, if this partnership is if there's that much conflict in it, then yeah. I know Judge DiSanto will assign a different one. This isn't the type of court that no, this is one and done. You have to get your own attorney after this. It's not like that with Judge DiSanto.
Mr. Gopal represented you at the pre-trial February 12th.
Yes,
that was
ma'am.
last month.
And Your Honor, yes, ma'am.
And he has continued to do what he's needed to do to get the discovery. So to say he's waited all this time is not a fair and accurate statement to say regarding Mr. Gopal.
And Your Honor, can I speak on that now? Can I rebuttal what you just said?
No, you cannot.
Okay.
I'm not going to keep going into a back
Yes,
and
ma'am,
forth.
you're right.
I'm not going to go into a back and
You're
forth.
absolutely right.
Mr. Gopal is going to send over the subpoena to McDonald's to see if there's any other video that exists regarding this incident.
Yes, ma'am.
In the meantime, sir, if you're going to retain counsel, then you need to make sure that you're doing it timely so that your attorney knows when all of these dates are and that's the date of the jury trial.
Yes, ma'am. And for the record, Your Honor. Go ahead, I'm sorry. Go ahead.
Sir, you don't get to tell somebody to go ahead. That's this.
I'm sorry, I was just saying because I made a noise and you looked at me crazily, so I was just saying my bad. I'm sorry, you can go ahead. I wasn't cutting him off or saying
Sir, stop right now. I didn't look at you crazy.
Okay.
I didn't look at you crazy. I looked up.
I think we understand where the problem is. It's the person bagging his prize maybe didn't fill the box and he got mad and started a fight. I don't know. This guy seems to have a lot of issues, temper issues.
Because of the noise you made when your attorney indicated he wanted to say something for the record, which is what his job is, to say something for the record.
Yes, ma'am. He can go ahead. I'm not saying that he can't. I don't know why.
You're correct. He sure can, because I'm telling him he can't.
Right, I don't know
Please
why
stop
he's in
talking
the
right
situation right
now.
now.
Please stop talking. Yes, Mr. Gopal.
For the record, Your Honor, back on February 12th, I was not originally scheduled to represent him. There was another attorney, I don't recall the name now, and at that point in time, Mr. Hoke and Mr., I think it was Dubois, had a blow-up, and he said, I'm not going to hire you, and so forth and so on. I then came out, spoke to him for the very first time, and started to track all this stuff down.
Okay, thank you for clarifying that.
Can I put something on the record, please? On the record, please.
What is that, sir?
My attorney admitted to you, ma'am, that he was supposed to put in a subpoena last time we talked. He did admit
Sir,
to you,
we're
but he
past
chose
that.
not to.
Sir, we're past that.
He's stating stuff that I did, I need to state on the record stuff that he did not.
We're past that.
You're right.
We're past that.
I just gotta get it on the record.
No, you
It's
don't need to get
ineffective
it.
counsel.
Sir, you don't need to get it on the record. He's not ineffective. He indicated, sir, he stated that he communicated with Mr. Cayley, the prosecutor. They located the video that was sent from McDonald's. They located the video from the discovery. So they didn't need to subpoena for the video at that point. They found the video. Now, you're stating that there's more video that exists. So now, Mr. Gopal is going to send the subpoena to see.
No, ineffective counsel just is. You don't bring that up during pre-trials. That happens at trial. You can appeal based on ineffective representation, but all you would get is a new trial if it was granted. You don't get a dismissal of it. At least not that I would understand. Not at least that's how I understand it. Let's say that.
There's more video, if it even exists.
Yes, ma'am.
Because quite frankly, if it doesn't exist, it probably didn't exist last month when he was looking for the video. In fact, I think we had a discussion about that, whether or not it would even exist because it's been such a time.
Yes, ma'am.
There is anything that prevented you from getting a copy of that video?
It's not my job, nigga.
Sir, before you even had your court date, there's nothing that prevented you from asking or requesting the video. You could have requested it, whether they accepted it or declined it, I don't know.
Contact on the people that work there. Me going there would be a violation of my contact, no contact. Me calling there would be a violation of my no contact.
Sir, when were you given the no contact?
From my PO. I'm on parole. I got the no contact paper on Kenneth Hamilton and on the lady that was there.
Okay.
So that would be a
You're correct.
violation.
You're correct. I was unaware regarding that being a no contact provision as far as that goes. But also, Mr. Goldpaw was not even part of this case until last month. So to say it's ineffective assistance of counsel, sir, is erroneous. He's been doing work on your file. He's been communicating regarding your case.
Yes, ma'am. That's your opinion, man.
He's ready in the courtroom, so she's ready in the jail. Okay.
And I'm just going to state as well for the record that the discovery order on December 11th, that was prior to Mr. Goldpaw's involvement, indicated video for McDonald's and as well as the officers. And then on March 5th, when Mr. Goldpaw was on this matter, indicated to adjourn to obtain McDonald's videos. So Mr. Goldpaw did what it was he was expecting to do. If you were to test today, sir, what would be in your system?
Marijuana, ma'am.
Do you have a valid prescription? Do you have a valid prescription for that?
I do, but it just expired the 19th of this month.
Okay, so did you request a
I'm in the
renewal?
process of a renewal, yes, ma'am.
What does in the process of a renewal mean?
Then I have to go through the steps. I gotta go through finding the people who I had last time, because I gotta search through my emails for who it was done to.
Okay, so if it's for medical purposes, sir, don't you have a treating physician that follows up on the use of the medicine?
No, ma'am. It's not like a medical like that. I got a card. They don't reach back out to you like that to renew it anymore.
No, sir, you're saying that you need marijuana for medical purposes.
Right,
So this court treats it as though it's any other type of medicine,
right.
which means that you're following up with your doctor on a regular basis to make sure that the medicine is working as intended.
Yes, ma'am. I have a prescriber for regular medication. I have a therapist that also is involved with knowing what my needs are. And I have a different prescriber who I have to go to for the card. So those are three separate things. I don't stay in contact with him. Once I got the card, that was that with him. My due process, what I do is with my therapist and my other people. Yes, ma'am.
Right,
So
so
no
if there's-
following up, I have not done.
If there's something from one of your treating physicians that indicates that that's the best course of medicine for you, then this court will accept that. Until then, you can't use it because you don't have a valid prescription, and I don't have anything from a treating physician that says that that's the course of treatment for you.
Yes, ma'am.
Once I have that, then sir, then you'll be able to use that.
Yes, ma'am.
Once it's been submitted to the court.
Yes, ma'am.
All right, bond end conditions are continued. And then we will see you back on June 18th for jury selection. You may attend the final conference on May 21st if you would like, if there's a resolution, but you're not required to be here on that day, okay?
Yes, ma'am. Just one more question for clarity. As far as the marijuana, is it even worth me renewing now that you just told me a list? I got like a prescriber telling me I need it? Is
Sir.
it worth it? Just for me to go renew it, so I still.
I need a prescriber. A prescriber. I'm just learning all sorts of terms tonight. Cheshire Cat, you're about to lose your position of trying to teach me new words.
I have it for my parole. My parole officer and all them is the reason I went this route, because they told me to go this route for it.
Okay, so let me just clarify this, okay? You're telling this court that you need marijuana for medical purposes.
I've been deemed that, yes ma'am.
Okay, you've been deemed that from somebody that you've seen one time,
Yes,
for a
ma'am.
very short time,
Yes, ma'am.
and you've never followed back up with that person.
Yes, ma'am.
So, if the purpose is for medicine,
Yes, ma'am.
then there should be some follow-up to make sure that the medicine is working properly,
Yes.
such as high blood pressure medicine, diabetes medicine, any medication, right?
So just to clarify.
No, I'm clarifying. There is a follow-up with doctors on a regular basis to make sure that the medicine is in fact working for its intended purpose. So, you have doctors that you treat with on a regular basis, correct?
If you say so, yes.
No, I'm asking you. You just said you have a therapist and another doctor that you treat with on a regular
Yes,
basis.
ma'am, who have nothing to do
Okay,
with the
hold
medical
on.
part.
If either one of them wants to send in a letter,
Hi, Cinnamon. Hopefully you're well tonight.
wants to write up a letter indicating that
Yes, ma'am.
marijuana is the more appropriate medicine for you to use, then you can just send in that letter. You don't even need to get your card for this court's purposes.
Yes, ma'am.
Whatever your parole officer's requirements are, that's something different.
So having a card, is that still okay or no? I'm just saying, so me having a card from a certified person who's approved to give those out, is that okay if I bring in that and show that I'm certified, like I've been approved for medical marijuana?
Is it from somebody that you have a treating relationship with, somebody that you see on a regular basis?
I don't know, ma'am, is somebody whose job it is to approve?
No, that's not my question. Somebody that you see on a regular basis for medical appointments and treatment, is it from somebody that does that?
I can get one. Yes, ma'am, I can get one. Yes, ma'am.
Okay. We'll see you then, maybe in 20 years.
Dates, please.
Oh, it's over. I told you. I was not really paying attention to the video tonight. I was the first one. This one was fun, but it wasn't as good as the first one. It really wasn't, but it was still good. Yeah. Anyways, thank you guys so much for hanging out with me tonight. I appreciate it. Let's see. Tomorrow, I don't have a lot written. I've got a lot written down for Friday. I think tomorrow. I think a lot of people took the day off tomorrow because it's my birthday. So yeah, hopefully we can get some good court tomorrow. I just don't have anything on the calendar. I've got one in Judge Washington's courtroom tomorrow morning. That's it. The other one was pushed back. I had a soft sit tomorrow that was pushed back till next month, but so that's not happening tomorrow. We'll get a bunch for Friday. But yeah, thank you guys so much for hanging out with me tonight. I do appreciate it, and we are set up to raid KFAR tonight. We raided KDZ last night. We're going to raid KFAR tonight. And then probably tomorrow and Friday will both be Lone Wolf. It's kind of been the schedule. Monday, Lone Wolf. Tuesday, KDZ. Wednesday, KFAR. Thursday and Friday, Lone Wolf. All right. You guys have a great rest of your night. I will see you tomorrow. And yeah, you're awesome. Until next time, bye.
Yeah.